find at your places. I'm Priyanka Vish from RN Progressive School. Today in this session, we'll be learning about the forms of business organization. As in the previous class, we have studied about the two forms of business organization. First was sole proprietorship and second was partnership. But here in this session, we'll be continuing with the partnership form where we will study about the different types of partners and also different types of partnership firms. And then the second form of business we'll be studying today will be joint Hindu family business. So these are the two topics which we'll be discussing in today's session. So we will start with the topic types of partners. As in the previous class we have studied about partnership. Partnership is an agreement between two or more persons who have agreed to share the profits of the business which is carried on by all or any of them acting for all. And partnership is formed by the agreement. Agreement can be oral and written. Written agreement is known as partnership deed, which contains the name of the firm, location of the firm, number of partners, capital contributed by each partners, etc. So all these information are present in partnership deed, which is a written document or written agreement. Now, today we'll be studying about the types of partners in partnership firm. As we know, in partnership firm, minimum partners can be 2 and maximum can be 50. So there are different types of partners who perform different activities in the partnership firm. So first, we will learn about active partner. Now, who are active partner? Active partners are the partners who participates in the management of the firm, or we can say who participate in the day-to-day activities which is carried on in the business. His liability is unlimited. We know in partnership firm the liability of every partner is unlimited. Unlimited liability means if the firm bears some losses, then all the partners will have to sell their personal property also to recover the losses of the partnership firm. This is what unlimited liability is. So the liability of active partner is unlimited and he contributes the capital in the firm. Whenever a partner is thinking to join the partnership firm, he has to contribute some amount of capital with him. And the active partner also gets share in the profit or losses of the company. So it is clear who are active partner. The one who participate in the management of the firm. The liability of active partner is unlimited. He contributes in the capital. He contributes the capital in the firm. So if he is contributing the capital in the firm, so he is entitled to get the share of profit or loss of the company. Now next type of partner is sleeping or dormant partner. We can call sleeping partner as dormant partner also. Now who are dormant partner? A sleeping partner, the partner who does not participate in the management of the firm. So here the sleeping partner is not active. He does not participate in all the activities which are performed in the firm or management. Second, these partners are bound by the activity of other active partners. So here all the activities of the sleeping partner, this activity is performed by the other partners who are performing in partnership firm. Now these partner contributes capital, so sleeping partner also contributes the capital. So if they contribute capital, they are entitled to get the share in the profit or loss of the firm. And the liability of sleeping partner is unlimited. So here it is clear who are sleeping partners. Sleeping partner are those partner who does not participate in the management of firm. Their activities are performed by the other partners and sleeping partner contributes in the capital. So they get share in the profits and losses of the firm, and also the liability of sleeping partner is unlimited. Now next is secret partner. So secret partner are those partner whose association or relation with the firm is not known to the outsiders. He contributes capital, participate actively in the management, and his liability is also unlimited. Although they actively participate in the management of the firm, that means all the business activity which is carried on in the firm, they are performed by secret partners also. Secret partner also contribute the capital. If they contribute the capital, so is entitled to get the profit or loss of the firm. And also the liability of secret partner is unlimited. Now, next type of partner is nominal partners. So, nominal partners are not the real partners of the firm. These partners do not contribute any capital, they do not participate in the management also, they do not have unlimited liability, and if they are not contributing any capital, so they are not entitled to share in the profit or loss of the firm. Now the question arises, then what is the role of nominal partner? So nominal partner basically lends their name and reputation for the benefit of the firm. So for the benefit of the firm, for the promotion of the firm, only the name of nominal partner is lent. As the nominal partner is the one who has a good reputation, he has a good name. So his name can be used for the benefit of the firm. Now he is liable to the outsider for the debt which the outsider have given to the firm, believing he is a partner in that firm. So according to the outsiders, nominal partners are the active partners of the firm, but they just lend their name. Rest of the activities, participation in the management, contribution in capital, unlimited liability, their share in profit and losses, these are not given, or these are not the rights of the nominal partner. Now next we will talk about partner by estoppel. Now who are these partner? The person who accepts that he is a partner in a firm or partnership firm by his own words or conduct. They are known as partners by estoppel. He is liable for the debts which the firm gets because of his reputation. Now partner by estoppel is also a type of nominal partner only. We can take the example, for example, if X is the active partner of the partnership firm and he applies for a loan. Mr. A, who is not the partner, he requests the financier to give the loan to the firm as he is also the partner in the firm. Then Mr. A will be considered as a nominal partner by estoppel. So here there were two partners, Mr. X, and A is the partner by estoppel. So X, who is the active partner of the partnership firm, he takes the loan from the financier or the bank, but he uses the name of Mr. A. Mr. A accepts that he is a partner by his words, and by his words only the financier provides the loan to the firm. So we can say Mr. A is a partner by estoppel. He is also lending his name for the benefit of the firm. Now next type of partner is partner by holding out. This is also a category of nominal partner. Now these are the partners who does not call himself as a partner in the firm, but who does not object also when others call him as a partner in the firm. Then he is called partner by holding out. Now here is a difference between partner by estoppel and partner by holding out. In partner by estoppel, the partner or the person, he was accepting that he is a partner in the firm by his own words. And in partner by holding out, the person is not calling himself as a partner in a firm, but if others are calling him as a partner, then he is having no objection in it. It is called partner by holding out. For example, if Mr. X applies for a loan saying that Mr. A is also a partner in a firm, and Mr. A shows no objection to the statement of Mr. X, then Mr. A will be called as nominal partner by holding out. He will be liable to pay back the debts which the company got by using his name. Now, if the firm will not be able to pay back all the debt, then who will be responsible? Then Mr. A, who is a partner by holding out, he will be responsible for all the debt of the company. So these are the types of partners who work in a partnership firm. Next we have types of partnership firms. In the previous topic we have studied the types of partner. Now this topic is based on types of partnership firms. So types of partnership firms, this partnership firm is categorized into two categories. First on the basis of duration, second on the basis of liability. So if we talk about the basis of duration, then on the basis of duration, the partnership firm is divided into two categories. First is partnership at will, second is particular partnership. So in partnership at will, this partnership firm is formed for an indefinite period, which is known as partnership at will, which means This type of partnership exists at the will of the partners and comes to an end whenever the partners desire so. So, any one partner can give notice of the dissolution and partnership will come to an end. So, here the partnership can come to an end by the will of the partner. If the partner desires that he wants to close the business or he wants to exit from the business, then he can do so. This is known as partnership at will. Next type of partnership firm on the basis of duration is particular partnership. Now, what do you understand by particular partnership firm? So, it is a type of partnership firm which is formed to carry on a particular venture. This is known as particular partnership. So, basically, this type of partnership comes to an end automatically on the completion of that venture. We can take the example, if two persons jointly get a contract for construction of a bridge, then these two persons may form a partnership to construct the bridge, and when the bridge gets constructed and is ready, then the partnership automatically comes to an end. So we can say that particular partnership is formed for a particular project or a particular venture, and after the completion of that project or the venture, the partnership is ended. Now, next type of category is on the basis of liability. So, on the basis of liability, partnership firm is categorized into two main categories. First is general partnership, second is limited partnership. So, in general partnership is a partnership in which the liability of all the member is unlimited. It is known as general partnership. So, it is a kind of partnership firm where all the partners' liability is unlimited, which means if the assets of the firms are not enough, then the creditors can settle their accounts by having claim over the personal property of the partner. So here, whenever the firm bears the losses, the personal properties or assets of the partners may be sold so that the firm can recover its losses. So each partner of general partnership firm can actively participate in the activities of the firm, and in India, all the partnerships are general partnership firms. Second is limited partnership. Now, in limited partnership firm, the liability of all the partners except one partner is limited to the extent of their share in the partnership firm. This is known as limited partnership firm. So, whatever amount of capital the partner is bringing in the business firm, that partner is liable for the liability of that amount only. For example, if a partner is bringing 5 lakh rupees with him as a capital in the partnership firm, so he will be liable for 5 lakh only. His personal property will not be sold if the firm is bearing the loss. He will be liable for only 5 lakh rupees, not more than that. This is what limited partnership is, where the partner's liability is limited, all the partners' liability is limited except one partner. Now, in India, limited partnership is not allowed and it exists in England only. So, basically, main features of limited partnership are that at least one partner must have unlimited liability. Liability of all the partners can be limited to the extent of their capital contribution. Partners with the limited liability are called special partners or limited partners, and the special partner is not allowed to participate in the management. Now, next we have limited liability partnership. So, this is also a type of partnership. As we know, in the partnership form of business organization, there are some merits of partnership firm and some demerits of partnership firm. So, to overcome the demerits of partnership firm, a new type of partnership firm existed, which is known as limited liability partnership. Now, limited liability partnership firm, here the liability of at least one partner is unlimited, whereas the rest of the partners may have unlimited liability. Second is, it is not affected by death or insolvency of a partner. Third, no right of the management to limited partners. Then, compulsory registration is required in limited liability partnership. Act of limited partners not binding on others. So these are the features of limited liability partnership firm which is not present in general partnership firm that exist in India. Now next is registration of partnership firm. How partnership firms are registered. So as we know, legally it is not compulsory for a partnership firm to get itself registered, but then also some partners prefer to get the firm registered because an unregistered firm suffers various serious problems. So here, registration of partnership firm means entering the firm's name along with the relevant prescribed particulars in the register of firms kept with the registrar of firm. So it is optional to get a firm registered. It is not compulsory for any partnership firm to get itself registered, because we know partnership exists only with the agreement, and that agreement can be in written and oral. So let's see what are the consequences which an unregistered partnership firm faces. Here are the consequences. First is, a partner of such firm cannot file a suit against the firm or the other partner. So if the partnership firm is not registered, in such case the partner cannot file a suit against any firm or any other partners. Second, the firm cannot file a suit against third parties. Against third party also, the partner cannot file any suit because its firm is unregistered. The firm cannot file a suit against the partner. Unregistered firm even cannot file a suit against the partners. These are some consequences which are faced by an unregistered partnership firm. So the procedure for registration of partnership firm means a partnership firm can be registered anytime, that is at the time of formation or the later on, whenever the partner desired to get it registered. So to get the firm registered, the partners have to apply to the registrar in a prescribed form along with the registration fees. So the firm can be registered with the desire of partner. Whenever the partner desire to get its firm registered, he can register the firm. And to get the firm registered, there is some procedure, that is the partner have to apply to the registrar along with the registration fees. So there are some information which must be supplied along with the application form. These are name of the firm, principal place of the business of the firm, or we can say address of the head office, the name of any other place where the firm will be carrying on business, or we can say the address of branch office, date of admission of the partners in the firm, name and permanent address of the partners, duration of the firm. So all these information must be supplied with the application form, and the application must be signed by all the partner. So this is the procedure for partnership firm to get itself registered. Now here is the next form of business organization, which is Hindu Undivided Family, which is also known as Joint Hindu Family Business. So this is a type of business which is carried out by the member of a Hindu Undivided Family. It is known as Joint Hindu Family Business. So here Hindu Undivided Family Business is governed by the provision of the Hindu Succession Act 1956, and the business is owned and carried by the member of Hindu Undivided Family. So we can say this type of business is not governed by any Companies Act, but it is governed by Hindu Succession Act, which exists under Hindu law. And who govern this business? Who are the owners of the business? Members of Hindu Undivided Family control this business. Now, the key aspect of this business is, and one should have ancestral property. The one who is owning the business, he should have ancestral property. Karta is the eldest member who control the business. Co-partners are the other members of the family who along with Karta manages the business. Now, there are two conditions for the existence of Hindu Undivided Family. These two conditions are, there must be minimum 2 male members to carry on the business activity, and there must be existence of some ancestral property. Ancestral property is inherited by the male member of Hindu Undivided Family, and the member who shares the ancestral property and who are entitled to get a share in the profit of Hindu Undivided Family, they are known as co-partners. So here Karta is the eldest member of the family who is the owner of the business, or who controls or manages the business. And who are co-partners? Co-partners are the members who shares the ancestral property and who are entitled to get the share in the profits of the business. Now, under Hindu law, there are two systems of inheritance, and these are: first is Dayabhaga system and second is Mitakshara system. So in Dayabhaga, this system prevails only in West Bengal, and under this system, the male as well as female members of joint Hindu family can become co-partners as well as co-partners. So this is the system which exists only in one state of our country, which is West Bengal. And also in this type of system, the male as well as female members, they can become the co-partners, and they should be of Hindu undivided family. Second system is Mitakshara system. So this system prevails all over the India except West Bengal, and under this system only male members can become co-partners in the joint Hindu family business. So here is the difference between the two systems. In Mitakshara system, it exists all over the India except West Bengal, and in this system only male member can become co-partners. Now next we have some features of Hindu undivided family. So first feature is formation. Now, for the formation of joint Hindu family business, there should be at least two members in a family and ancestral property to be inherited by them. Two male members should be there in the family. Only then the business can be formed. And the business does not require any agreement as membership is by birth. So here there is no compulsion for the agreement. Anyone in the family can become the member by taking birth in that family. So it is governed by Hindu Succession Act 1956. Next feature is liability. Now the liability of Karta. Karta is the eldest member of the family who is owning or managing the business. So liability of Karta is unlimited, whereas the liability of all the other members of the joint Hindu family business is limited up to their share in the business. So here Karta, who is the owner of the business, his liability is unlimited, which means if the business suffers the losses, then the personal property of the Karta will be sold to cover the losses which is beared by the firm. And the liability of other member, it is limited up to their share in the business. Now the Karta's liability is unlimited, so his personal asset can be used for paying back the debts of the business. Next is control. So the joint Hindu family business is managed and controlled by the senior most member of the family, who is called Karta. Only the Karta will have the legal rights to enter into the contract with outsiders. He will only take the decisions of the business, and the other members have no right to take decision in the management of joint Hindu family business. So overall control of the business lies with the senior most member, which is known as Karta. Next is continuity. So the joint Hindu family business continues even after the death of Karta. Why? Because after the death of Karta, the next senior most male member automatically becomes Karta and carry on the work. So the business comes to an end only when all the members notify legally that they are not the members of joint Hindu family business. So the continuity of the business is not affected by the death of Karta. The next senior most male member will automatically become the Karta and he will manage the business. Next feature is minor members. So in joint Hindu family business, a child becomes a member by birth only. So there is no restriction for a minor to become a member of the business. He automatically becomes the member of the business by taking birth in the family. So this was all about Hindu undivided family and its features. So in this session we have learnt about the types of partner and types of partnership firm under the partnership form of business organization, and we have also learnt about joint Hindu family business and its features. So in the next session we'll be continuing with some more forms of business organization, That's all for today. Thank you.